All right, everybody. Justice is a Process is live here. We're going to do a little show, quick little show here on an issue that came up today in the uh, Franklin Tucker case. And the reason why I'm doing this is because I wanted to highlight this situation that occurred in court today, because it's another example of what's going on down here in this case, the way and it highlights the way the judge, the state, although the judge in this instance made the absolute right ruling, but it's showing you how these prosecutors, and in my opinion, this almost rises to the level of misconduct. If I was Mr. Tucker, I would even consider filing a complaint for misconduct in the way he conducted himself in this situation. I'm going to explain it to you. Luckily, at the very last moment, I don't know if Mr. Tucker's advisors or someone was contacting him in court to tell him to say the right thing to the judge to move this thing, but it deals with the concept of hearsay, right? And what you're going to see what the prosecutor was trying to do in this instance is they were trying to admit a prior consistent statement. Now, this is a very murky area to get into, right? Commonly, prior consistent statements are not allowed in because the court doesn't want to have a compounding effect. In other words, you're allowed to come in, testify to what you're going to testify to, and any prior statement you've given is considered hearsay. It's a statement that's not related to what you're saying. It was prior made, and it can't be brought in and played for the jury. You can't have other people come testify and say, I heard him say this, I heard him discuss this, because it creates a scenario where credibility is being derived simply by the fact that this statement was said multiple times, and it's not, and you're not judging the credibility of the statement by the validity of what's said. Now, inconsistent statements are allowed to be brought in for purposes of impeachment, and in this case, Mr. Tucker um, brought in an inconsistent statement here from Travis Johnson showing his prior inconsistencies. Now, what the state tries to do is they're trying to slip in a prior consistent statement. Now, here's the deal. Under the guise that there is a carve out in Florida Rules of Procedure under hearsay that says if you have a prior consistent statements can come in post cross examination if an issue has been raised in regards to um, them changing their story, um, and changing their story recently, a recent change to their story. They can bring in a prior consistent statement showing the consistency of the statements. In other words, if they're alleging deception, in other words, or they're alleging that there was an encouragement of someone else, that you can bring in a prior consistent statement once this has been uh, made an issue by the defense and they've been cross-examined on it. If they've made a statement at the time that you would allege, or prior to the time that you would say there this coercion occurred, or this encouragement occurred, or the uh, and for instance, what we're talking about here, say you have a police officer and it says, okay, this police officer, in this case, what Tyrone Tucker was alleging here is that Officer Phelps uh, Penny Phelps had fed him a story. So the prior consistent statement can come in if you can show that he gave a statement to someone prior to ever having contact with Penny Phelps. Um, you can bring that in and you can say, okay, here's this statement that was made prior to ever having contact with Ms. Phelps, and he was saying the same exact thing. Now that would be able to come in and bolster it. However, however, there is the Supreme Court at the United States Supreme Court. Uh, the courts have been pretty clear now, and there's even been a substantial law written in regards to this, and it's called the premotive rule, right? Meaning it's a prior consistent statement can only come in as long as it's pre to the motivation that you're claiming exist. In other words, it's got to be prior to whatever instance that occurred where this individual comes in contact with the person that's feeding the story. So in this case, it would be prior to Penny Phelps having her conversations, feeding him the stories. This is when this statement. Now, there's prosecutors aware of this. There's Florida state law, law review done, as far back as I found 1997. You've got just a plethora of cases that deal with this. You've got United States versus Ayala, which deals with this specifically. United States versus Norwood. Look, and again, maybe this prosecutor is truly not aware, but I would highly doubt it. But what he's trying to come in, they've been very clear on this. You cannot bring in a prior consistent statement if it predates, if it postdates the time of the fabrication that you're alleging, or the person that would provide the fabrication. Now, this prosecutor was attempting to use against Tyrone Tucker his own lack of knowledge of the law, and he was anticipating that Tyrone, at first, Tyrone Tucker wasn't really understanding how to deal with this issue. And then he finally made the right argument where he says, wait a minute, this statement is after he had contact with Penny Phelps. So therefore, it's very clear, and the courts have found it's reversible error if you admit a prior consistent statement after the fact. In other words, after it's already been, after it's already been contaminated, so to speak, after the incident occurred where Penny Phelps, if there's no other statement that exists, if all statements prior to this were inconsistent with the testimony that's going on after he has contact with Penny Phelps, it's not admissible, right? You can't use that. But the state comes up with this because they're desperate, because they knew that Johnson's testimony in this case, whether you like it or not, was a disaster. He's not credible. He did not come across, in my opinion, as credible. It's a complete disaster. And in a last-ditch effort, this prosecutor was willing to throw it. And he even acknowledges, we're going to watch the clip. And he even says something very interesting. He says, this is a unique case where we get a one-time shot at this type of situation. Because what he's anticipating is if they are able to, by some miracle, get a conviction, he anticipates Tucker will not return to court without an attorney at that point. He will have an appellate team assisting him. And if he comes to court again, it would be a situation where if he got another trial, he's going to have an attorney in there. Because if he's an attorney in the courtroom, based on the case that's been presented, this case will be a very quick not guilty verdict. The problem we're going to run into right now is, what is he going to do next week? Because the state has rested. And where does it go from here? How does the case go? Does he testify? And how does that come across to the jury? But at this particular moment, if you're applying the presumption of innocence, he's found not guilty. If you have an attorney who can explain that to the jury, he's found not guilty. Anyways, let's jump into the clip here. I want to play this for you. But this is something we got to highlight. These are the things we're watching. This is what we've got to look at, because we got to make sure that things like this, prosecutors like this, judges, luckily the judge intervened here. He was close. You're going to see he was close to allowing this to happen. And he was kind of, like he wanted to do it in one degree, I think, because I think he doesn't like Tucker. I think he's absolutely fed up with him. And of course, he's part of the system down here. He's part of the system's being called into question. So, but at the same point, he knew that this could really, really look bad. This could get them in a lot of trouble if they let this go. So anyways, let's look at the clip. I'm going to show you some information then, and then we're called a day. So let's get into the clip here. Give me a moment while I pull it up.
So first of all, I don't know what O is. I mean, you ask the witness if he remembers back in, I think, April 2022, making another statement, and
That's right.
moved O into evidence.
Yes, sir. So, Judge, I'll let me explain. In April of 22, when we approached the defendant about potentially doing a deal with him, we said, before we talk about anything, we want a sworn statement. And he gave us a sworn statement. Normally, that statement would not be admissible. It would be hearsay. However, under Rule 90.801.
No, wait a minute. So O is some,
O is that proffer that he gave, an audio of the proffer or the sworn statement that he gave to my office.
so you're moving it into evidence on Mr. Tucker's objecting, so let's hear what the state's basis of admissibility is.
90.801.
So just give some context here to what we're seeing. The state right now is trying to move this statement in. What is a prior consistent statement? He's gonna go over the law, but it's important you understand, and I want you to listen to exactly how he tries to argue this. And the judge starts to struggle with, what are you doing here? And to me, like I said, Mansfield, even his colleague eventually says, don't do this. And this is just telling you how desperate they are to try to get this man. Why? I don't know. I mean, it's pretty clear to me the evidence doesn't exist, to me, to prove beyond a reasonable doubt what they're alleging. So why are you trying to do this in an unethical way? Why are you trying to subvert the justice process by trying to go around things? But anyways, let's get back to watching this here.
Subsection 2, subsection B. A statement is not hearsay if the declarant, Mr. Travis, testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is consistent with the declarant's testimony and is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. This defendant has been attacking this witness now for a day and a half about, you'd do anything to get out, wouldn't you? You'd say anything. You even said in the video, I'll do anything you want. He has made allegations of a fabrication on this defendant in order to get a deal. He's made allegations of improper influence of Penny Phelps. And he's made allegations of the motive to do it, meaning this defendant did not want to go to prison for life. So basically, he's here saying anything he has to say in order to avoid that. That's specifically what this rule is meant to address. So normally, a prior consistent statement would not be admissible, but now that that has been established, it is my position that statement should be admissible as a prior consistent statement offered to, to rebut allegations of improper influence, motive, or recent fabrication.
And the defense's position is?
The defense's position is that, again, as far as his motives, as far as the deal he cut, yeah, that one is self-explanatory. I didn't have to point that.
Now, this is when I got very nervous, because it's clear the only thing he should be talking about, the fact is, in this instance, is, hey, these statements, this statement he's giving is post Penny Phelps. In other words, it's after the waters have gotten muddy. So it's irrelevant, and it can't be admitted under the promotive rule. And of course, a lawyer would have several cases to present to the judge, and this thing would be kicked in 2 seconds. But Mansfield knew he wasn't going to be prepared like that. He knew he wasn't going to have the knowledge of that. And that's where the disturbing fact of this whole thing lies with me, is they're taking advantage of that fact. He's taking advantage of that fact and in bad faith, making a bad faith argument. And him as an attorney, him as someone who's a member of the bar, knows that this is an improper use of that statement. And he's asking the judge to effectively say, let's take advantage of the fact this is a pro se defendant. And in my opinion, this is in violation of the code code of conduct for attorneys in the state of Florida, and should be addressed, by a complaint by Mr. Tucker to the bar. And whether anything comes of it or not. It's just something that should be made. And again, one of the other issues that Mr. Tucker needs to also start doing, which he's not doing, is start making a record. He needs to ask the judge to make a record, make a proffer for the record, so it's part of the record, and that he can then utilize that just in the event that he does get convicted somehow, that he has it. But at the same point, if he wants to reference back to this, he can have a record that he can then take, and he needs to state it outward. I'm making a record because I intend for appeal and for purposes of filing a complaint. Maybe I'll file it tonight. Maybe, but he needs to be on top of this, addressing these things, because once he does, these individuals are going to change the way they're going to act. They're going to change the way they're going to approach it. Anyways, let's get back to listening.
As far as Ms.
Hmm?
Phelps, Ms. Phelps, is she going to be addressed in that statement? The statement that you're trying to enter into evidence on cross? I mean, not a cross, I'm sorry, on redirect. You're trying to introduce new evidence into redirect, and does that actually establish, does it say anything about Penny Phelps?
I don't know.
Because, I mean, that's what he's using to establish this law here. He's trying to say that, because we question Mrs. Phelps's motives, that would establish this law.
It's not a question of Phelps's motives. It's a question of this defendant, or this witness's motives. He has been alleged to have fabricated this story in order to get a deal. He is alleged to have been improperly influenced in order to provide this story. This is specifically what this rule is designed for. It is specifically designed for a witness such as this who has been attacked by his motive for testifying, the content of his testimony being improperly influenced, and that it was fabricated to get a deal.
But does it allow you to enter new evidence on redirect?
Well,
Well, Judge, I'm not teaching law to the defendant, so.
We're having a legal argument. This is exactly what when this whole business about the defendant wanting to play the interview, interrogation, whatever you want to call it, of Johnson with Penny Phelps, this is what I don't want to say warned about, but acknowledged that the door may be opened.
Yes, sir, that is correct.
I understand, Your Honor.
Excuse me?
I said I understand, Your Honor.
Okay, so now the question is this within that rule? So what's the rule?
Judge, it's 90.801, parentheses 2, subsection B.
What subsection?
I'm sorry, Judge, subsection 2B.
Okay. The statement is not hearsay if the declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement. And the statement is, subsection B, consistent with the declarant's testimony. It is offered to rebut an express or implied charge against the declarant of improper influence, motive, or recent fabrication. I don't think this is recent fabrication, because recent fabrication would mean that somehow or other he's being alleged to have, in the very close to his testimony, fabricated, and then the advocate for that witness
Now, this
said,
is when,
no,
if you see
here's something that he
Mr.
said
Tucker, he's there on
months
his
ago
phone, it
that
looks like.
shows that this isn't recent fabrication. So it seems to me it's improper influence that the Penny Phelps interview was played by the defendant to say that Penny Phelps fed you this
Correct.
narrative, to use the term that's been employed here, and you basically said, yeah, that's it, and it was her idea, not his idea. So, just the timing that I'm wondering about here. So, the timing was the Phelps interview was in, when did we say? In
2017, Judge.
And this is the part when the prosecutor gets outed for what he's trying to do. And his partner, you're going to see him jump up and run over to him and say, just withdraw.
Want to admit is in 2022. So could you just explain the argument again, Mr. Mansfield?
Right, Judge. So now that he has attacked the veracity of his statement as having been coerced by Penny Phelps, well, he gave another statement almost 5 years later, and it's consistent with the testimony he gave this jury on direct examination. So, again, if it was the Penny Phelps story, well, 5 years later, he gave a consistent version of those facts, identical to what he testified to this jury today. I'm sorry, during this trial.
Okay, and so anything further from the defense?
Well, I believe you already admitted there's inconsistencies between the interview he gave with Penny Phelps and what he's given today. Why would that be any different in that statement?
Not the inconsistencies. I believe the whole implication that the defense is wanting to say is it's basically the whole thing is a lie. That it's Penny Phelps' version of events that Johnson has just adopted as his own in so many words, and he's fine-tuned it a bit. Yes. But
Your Honor,
yes,
if
sir.
I may, the statements that he made, again, Penny Phelps' time.
And here he comes. Now watch what happens.
However,
They just realized they got caught.
Yeah, he's had 6 years now to fine-tune those statements. Right. So, again, even all the, yes, he was there. He can draw a map. Yes, he's there. He could do all that. He could do everything that the state's saying. That's true because he was there. That's very simple. And yes, because he was there, he can give all that information and probably keep it accurate. The part that's problem is that Penny Phelps gives him the one key that he needed to get that deal. I'm the getaway driver.
Judge, he keeps arguing the very nature of why he keeps arguing that Penny Phelps unduly influenced this defendant. And the rule allows for me to play a prior consistent statement that corroborates his version because the defendant has attacked it as being.
And that's the incorrect statement of law right there. It does not allow that because of the
this prior inconsistent statement.
because of the
that would make
pre-motive
sense if
rule.
he had actually given that consistent statement.
Here he hits it
prior
right here.
to Penny Phelps. I'm sorry, prior consistent statement prior to Penny Phelps. Then it would make sense.
And Mr. Mansfield did not expect that he was going to make this argument. And watch what happens next. There they are, they're talking, and they go, oops, well, he's smarter than we thought.
Judge Jones?
yes.
In an abundance of caution, because I don't want to create an appellate issue. I'm not going to move it in. I'm not going to seek to move it in.
I think that's a wise choice, because one way or the other, it's a close call. I mean, one way or the other, it's a close call.
I truly believe this is the kind of trial that you get one shot at, so I don't want to create that issue.
Fine. May I ask, just, do you have a witness standing by?
Yes, sir, we do. Two of them.
All right, so a couple things I want you to focus on there. One, what we just ended with, what he ended with. I truly believe this is the type of trial you only get one attempt at. That should be captured in a record. If Tucker ends up convicted, that tells you the frame of mind of what they're thinking here. They know they have a weak case. They know they have a case that would never survive a defense attorney being in that courtroom. And they know they have an opportunity here where they're able to essentially get things in, get things done, do things they would never normally be able to do if an attorney was present. That's where the wrongness of this situation is, because they knew that they shouldn't have been admitting that statement. He knew that statement was not legally admissible. The judge knows this, but the judge is sitting here once again, same thing that's going on in this entire case, protecting each other, protecting each other's bad acts and bad behavior, and covering it up. And the judge was left in a rock and a hard place, because he was going to have to give Tucker a big win here and say, well, we're going to rule against you. And that's when his cohort comes up and says, listen, back off. Tucker's making the argument. If the judge rules here, we're going to get reversed. You're going to give him a new trial, and this will derail the whole thing if we get lucky enough to get a conviction. Now, give me a moment here. I want to show you a couple things in support of this and what I'm talking about here, and then we'll call this. But I felt this was important enough of an issue to highlight here, just to show everyone exactly what's going on down here in Florida. All right, guys, so let's have a look at this here. So this is the Florida State University Law Review that deals with prior consistent statements in the promotive rule. And you're going to see here, this specifically deals with this issue. It states that, it gets into the entirety of this entire issue. We're not going to go through this whole thing, but it talks about how the main issue when it comes to the promotive rule, pre-motive rule, is essentially, when does this prior consistent statement occur, especially if it deals with fabrication, if it deals with a fabrication issue, or if the defense is alleging that there was influence being applied to the statement. And it clearly states that in order for a statement to come in, it's got to be prior to the influence, or the introduction of the influence into the situation. Now, this is something that was part of that was discussed in 1997. Prosecutor Mansfield's been around for a long time. The judge has been around for a long time. The idea that these gentlemen didn't know about the pre-motive rule, didn't understand how to apply the law in this instance, is ridiculous. Absolutely ridiculous. Now we're going to go, and I'm going to pull up another document here. And this is several cases that deal with it, and it breaks down, but I'm going to focus on United States versus Ayala. And if we go down this list, all of these deal with this, but this is the most recent case from the 2020 term of the Supreme Court. And it states specifically in here that the prior, if you're watching this here, the prior statement admitted as substantive evidence must precede any motive to fabricate or improper influence that it is offered to rebut. And two, but really that's it. I mean, that's the main core of this. And in this instance, in this case, that line right there is it. Now, obviously, Mr. Tucker wouldn't have this information necessarily at his hands. The way they introduced it, and the judge even implied that in there, the way this is being introduced, the timing of it, the fact that they were giving Mr. Tucker no time whatsoever to research this issue, knowing he's a pro se defendant, knowing he has no knowledge of the law, and that they were going to try to spring this on Mr. Tucker in court, and then have the judge come in and say, okay, you were warned about this, Mr. Tucker. And the judge came close. You heard it. He came very, very close to admitting this. And then Mr. Tucker started coming to, and the judge kind of was giving him hints. And then Mr. Tucker finally tied it together and started talking about the fact that this statement was post the improper influence. And as a result, the judge started to kind of vacillate back and forth. And it was at that point that Mr. Mansfield realized, hey, the gig's up. This could really cause a lot of blowback. But I believe this goes even further, because this goes to potentially even look at saying, hey, are there ethical implications? Because again, Mr. Mansfield, as a member of the bar, absolutely has a obligation to adhere to the rules of conduct, and to make sure that when he's putting forth arguments, that he knows are are proper. And in this case, the idea that a prosecutor wouldn't be aware of the promotive rule, wouldn't have been aware of the fact, and he makes an argument in open court that should be admitted simply because there was a prior statement that was consistent with his testimony today in 2022, knowing that that Detective Phelps was, introduced the improper influence back in 2017. As a result, any statement after 2017 would not be admissible. So to me, this is just absolutely horrible. It's disgusting that he did this and acted that way. And something needs to be done about it. Something absolutely needs to be done about it. And, whether or not anything is done, who knows? But I'm telling you that that was absolutely horrible, absolutely disgusting. In what was done in this situation. So, anyways, I think that's where we're going to leave it at, guys. But I wanted to bring this to the forefront. I wanted to bring attention to this and what happened in this courtroom, what this skilled prosecuting attorney attempted to do. And I really wanted to set in the fact that, the individual in that defendant's chair, acting as his own attorney, is facing the rest of his life in prison. So when a prosecutor attempts to do something like this, and attempts to subvert the rules, attempts to knowingly attempt to try to get something around the rules, and knowingly does this, and attempts to do it in a way that's designed to trick Mr. Tucker, designed to get it in over his head. Absolutely disgusting. It would never have been done if an attorney was in that courtroom. And Mr. Mansfield should be held accountable for what occurred. And that judge didn't do enough. That judge let him walk. Now, whether or not there might be a discussion off record, there should be. And Mr. Tucker should absolutely consider filing a complaint against that judge for allowing that to happen in his courtroom, for Mr. Mansfield. And there should be future investigations as to what exactly is going on in that courtroom and the collusion that I believe is occurring between judge and prosecutor in that courtroom right before our eyes. Anyways, guys, I appreciate you tuning in, and we'll be back watching this trial tomorrow. So tune in as the defense begins its case, and we'll see how this thing, where the results go. And in the meantime, guys, let justice prevail, and I'll talk to you soon.